Good afternoon, everyone. Good morning. We're between you and lunch, so we're going to try to be as entertaining as possible this morning. I'm Norm Simon, co-chair of the advertising litigation practice at Kramer Levin, and Eileen, Patt, one of my partners. And what we're going to do today is provide an overview of significant trends that we've identified in the advertising litigation space over the last year. We're going to look at Lanham Act, NAD, as well as consumer class action cases. Some of these trends are oldies but goodies, some are new, and we're going to start with an oldie but goodie, which is the beginning. What is actionable advertising? Very commonly a question that's presented, and a very common question in that regard is the question of whether or not something is actionable as an objective claim versus non-actionable puffery. And we'll start in the Lanham Act space at some decisions in that regard this year. They both involve the use of the term best, both in connection with attorney advertising, and really illustrate how the context matters, and probably just as importantly, the court or the trier of fact matters. These are very context-specific and judge-specific outcomes. So we had, from the Southern District of New York, the Davis case. That involved an online review platform where attorneys' services were promoted, and certain lawyers who paid got superlatives attached to their names, including best lawyers. And the court determined that that kind of a claim, best lawyer, was not actionable given no other context because it was mere subjective commendatory language. In contrast, a very similar use of best for attorney advertising, but ascribing a particular practice area and a particular geographic area. Best advertising lawyers in New York, that would be Kramer Levin, just kidding. That was deemed to be actionable. Because there it was reasonable to conclude that attorneys could be objectively measured relative to each other in a particular area and in a particular practice. So, in addition to Lanham Act, we also saw the question of puffery being analyzed this year, as we have in the past at NAD. And here we also have an illustration of the use of the term best and how, depending on the context, it can come out very differently. In the LG case, the claim best TV ever was evaluated by NAD. And NAD found that to be puffery, not actionable, because it was referring to the television as a whole product and didn't call out specific measurable attributes of the television, nor did it make an objective comparison to competitors. So that fell in line with the type of general boastful statements of pride in a product that NAD and courts too find to be non-actionable puffery. In contrast, however, in the Mahindra case, NAD, and recently affirmed by NARB, held that the claim best warranty was not puffery. That, in contrast, was actionable because a warranty, a specific product attribute, could be objectively measured and compared. NAD drew a distinction about best for the product as a whole versus for a specific attribute. And most recently, in the Goya Foods case, a variation on best, the term favorite, was evaluated by NARB. And NARB affirmed NAD's conclusion that the claim Puerto Rico's favorite pasta was not puffery. That was an objective, actionable claim. Because while consumers might have different reasons for viewing a pasta as their favorite, NAD and NARB found that they certainly can understand when they're being asked, if they're surveyed on the issue, what their favorite is, they know it when they see it, and they could objectively rank it. And so it was not deemed to be puffery. But NARB did note in its decision that puffery decisions are, in fact, very fact-specific and context-driven, and the panel's decision is not inconsistent, in NARB's view, with finding the term best to constitute puffery in other contexts.
Great. So in the consumer class action space, let's talk about the Fyre Festival. So for those of you who are unaware, it was billed as a luxury music festival in the Bahamas. Tickets cost thousands of dollars. Consumers were promised gourmet meals catered by very famous chefs. They received that. Consumers were promised luxury tents with all the comforts of home. They received this.
I was upset I didn't get a bay room upgrade here. I mean, it puts it in
perspective.
Yeah,
you could have had that. So. So this festival was co-organized by Ja Rule. For those of you who, like Norm, didn't know who Ja Rule is, Ja Rule is a musician. He was very big in the 90s and the early aughts. And this is a clip of him from a Netflix documentary on the Fire Festival, which if you haven't seen it, I highly recommend it. It's wildly and entertaining. But this is a clip of him after the fact discussing the promotion of the Fire Festival with his employees. Let's see what Ja Rule had to say.
We made a mistake, we'll get past it.
I mean, granted, nobody died, but we did flat out lie to the public about what we're giving them. I mean, that's fraud. Like, and that's not okay, like, as a company operates.
That's not fraud. That's not fraud. That is, I would call that false advertising.
That's not fraud. That's false advertising. We don't need to worry about getting sued, right? Well, turns out he did. Unsurprisingly, he was sued along with others at Fire Media. As to Ja Rule, consumers challenged statements on his Instagram page that Fire Festival looks set to be the biggest FOMO-inducing event of 2017, and the debrief, think Coachella times 1,000. Well, the court held that these statements were non-actionable puffery, and the case against Ja Rule and other individual defendants were dismissed. So moving away from puffery, what about an image alone with no accompanying affirmative representation? Is that actionable advertising? Well, in January, a court dismissed a complaint alleging that Lenovo deceptively designed and marketed its phones to give the appearance that the phones have two speakers with those two grills there that you see on the side, when in fact one grill was a speaker and one grill was a microphone. And the court dismissed the complaint and said plaintiff failed to actually plead that defendant made any misrepresentation. And the court held that accurate pictures of the phone with the two grills cannot be materially misleading.
Moving on to another trend this year, disclaimers. This is one that we also have seen in the past. But the first case is actually a twist on disclaimers. This is a Lanham Act case that involved a challenge to the disclaimer itself as an advertising claim. This was a case involving the defendant's peptide product, and on the bottle were the representations not for human consumption and research purposes only. And those were attacked as false disclaimers intended to evade law enforcement scrutiny because the plaintiff alleged that the product, notwithstanding those disclaimers, was in fact marketed for human use. The plaintiff pointed to a website that the defendant ran that was targeted to bodybuilders and made claims like the product led to rises in lean body mass and decreases in body fat. The defendants argued that these statements were not false because they warned consumers that the products are not safe for human consumption. And that whatever was said in a separate advertising forum was not relevant to the question of whether these statements were actionable as false advertising themselves under the Lanham Act. A court in the Southern District of California agreed and granted summary judgment in the defendant's favor. The statements for research purposes only, not for human consumption, were in fact not literally false, nor false by necessary implication. As the defendant asked, where's the false statements? The status of the products as unsafe for human use is not itself false advertising. And although the plaintiff asserted that the products created health risks, they didn't actually offer proof of the falsity of the disclaimers themselves. So the real aim, according to the defendant, was really an attack by the plaintiff on the mere sale of the products, and that is not in and of itself actionable under the Lanham Act. So moving on to the NAD, and an example of a more traditional analysis of disclaimers, NAD often is confronted, and was again in 2019, with the question of whether or not disclaiming language is effective to appropriately qualify a claim. Here in this Reckitt case involving Woolite, the claim at issue was no stretching, shrinking, or fading. And the disclaimer stated that Woolite will not cause shrinking, stretching, or fading. And so the issue here, NAD found that this was an absolute message, that clothes that are washed using this detergent will not experience any stretching, fading, or shrinking, But the testing that was offered by the advertiser was designed only to show whether woolite itself would cause any of these physical dimensional changes. Not that the garment wouldn't experience any of that at all on account of, for example, the washing machine or the mechanical washing process. And so for that reason, NAD invoked its well-established principle that the disclaimer cannot contradict the main message of the claim. And having found that the claim was a broad one, speaking to the fabric overall not experiencing any of these dimensional changes, the disclaimer therefore was contrary to the main message and had to be discontinued. In addition, as it often does, NAD evaluated whether or not it was clear and conspicuous and found that even if it were an appropriate disclaimer, it was not clearly and conspicuously presented.
Okay, in the class action space, we'll get to formal disclaimers in a moment, but first, the circumstances under which contextualizing language on the front, side, or back of a package can cure a plausibly misleading statement. So in May, a court scrutinized the labeling of Neutrogena's Light Therapy Acne Mask, which was powered by an activator that came with the mask. And plaintiff alleged that defendant advertised the activator as capable only of powering 30 sessions, when in fact the activator had sufficient power to power many more sessions, but was designed to cut off at 30 sessions. And plaintiff's theory was that when consumers purchase a battery-powered device with batteries included, they reasonably expect that they're purchasing the battery's full capacity. And the court said, okay, that may be a reasonable baseline expectation, but the packaging here contains several statements that affirmatively dispel that expectation with respect to these products, informing consumers that each activator is designed to allow the mask to be used for exactly 30 treatment sessions, no more, no less. And the court specifically looked to the two statements on the front that are circled there, which if you can't read them, say activator with 30 daily treatment sessions included, and contains mask and one activator with 30 daily treatment sessions. The court also looked to the back panel, which said activator counts the number of treatment sessions remaining for you, and actually the back of the package also told consumers that they had to purchase a new activator after the 30 treatment sessions ran out. And the court said, whether you look at these statements individually or collectively, no reasonable consumer can be deceived. Similarly, just last week, the Ninth Circuit affirmed an order dismissing a complaint alleging that Ashley Furniture deceptively marketed its DuraBlend furniture products as comprised entirely of genuine leather when they weren't. And the panel was persuaded by unambiguous disclosures that appeared on the front and back of a hang tag that came with the furniture, and they're both depicted there on the screen. The court looked to the front label disclosure that at the bottom informs consumers that the product has only 17% leather. And on the back says, DuraBlend is material that contains ground, pulverized, shredded, reconstituted, or bonded leather and is not wholly the hide of an animal and should not be represented as being 100% leather. So the panel looked at those disclosures and said, neither of these are hidden or unreasonably small. And the panel was particularly persuaded by the fact that the front label disclosure appeared immediately next to the list of DuraBlend's features. The panel also held that the hang tags disclosures were truthful and not deceptive, and truthfully state that DuraBlend, unlike other imitation leather products, actually has some leather, without deceptively suggesting that DuraBlend contains intact animal hides like genuine leather. So the asterisk. Can it cure a plausible misrepresentation at the pleading stage? So to illustrate the answer to that question, let's look at two cases that were decided this year in the same district that analyzed the same issue and came out different ways. So the first, decided in May, dismissed the complaint. The court observed that asterisks are very common to inform consumers that they have to look elsewhere on the package before applying their own assumptions. The court also was persuaded by the fact that the disclosure itself, which here was on the back, actually discloses the fact that plaintiff complains it omits. By contrast, in the Anthony case, decided in January, the court denied the motion to dismiss. The court held first there was a question of fact as to whether a reasonable consumer would notice and follow the disclaimer. And second, and more fundamentally, the court dug into the language of the disclosure itself and found that it was ambiguous. So in other words, unlike the Sandus case, the disclosure at issue here was not clear and did not actually disclose the fact that plaintiff complained was omitted. So the takeaway here, really two things we already know, right? One, that decisions on dismissal motions are largely judge dependent. And two, your disclosures need to be clear and conspicuous.
So let's move on to another area that we saw a lot of activity in this year, and that is geographic origin claims. We will start with the Lanham Act, and this case out of the District of Utah. This was a case where there was a jury verdict in favor of the plaintiff. The defendant moved for judgment as a matter of law to overturn the jury's finding of misleading advertising, and that was denied by the court. The plaintiff alleged that the defendant falsely advertised the origin of its baked good products by using the term local as a tagline. The allegation was that that suggested that the product was made in Utah, that the bread was actually baked right there in Utah, when in fact it was shipped in from out of state. The defendant in the case argued that the term local is not false or misleading in itself because it's not a specific geographical place, and it's also not material to consumer purchasing decisions. Well, the jury disagreed, and the court basically held that the jury was perfectly able to make this finding that this was a statement of fact and a geographically descriptive term that was in fact eligible for protection and for action under the Lanham Act. The court observed that a term does not need to designate a specific geographic origin, a particular place, in order to be actionable. The court further went on to find that it was appropriate for the jury to make its finding because to suggest that bread products were particularly fresh and of high quality by using that term, that is not necessarily an appropriate use of the term, and it could be, in fact, deemed misleading to consumers. So the defendants have filed an appeal. It is pending in the 10th Circuit, and we'll see how this turns out. In terms of the NAD space, as Ron mentioned, there's a lot of activity with respect to Made in the USA. Ron actually touched on this case briefly, the J.B. Weld case. This presented NAD with the question of whether or not all of the constituent elements of the particular epoxy product here, the tube, the cap, whether all those pieces were more part of the product or part of the packaging of the glue itself. NAD, as it does, looked to the FTC policy enforcement guidance on Made in the USA claims, which looked to the all or virtually all standard, and it found that the policy was really silent on the question of how to sort of evaluate this overall product as product or packaging. NAD came out finding that this was, in fact, all part of the product because these components, were the cap, the tube, were all integral to the consumer use of the product as intended by the advertiser. For example, to prevent the glue from drying out between uses, you needed that cap. To allow precise application of the product, you needed these parts, and to prevent the different constituents to prematurely mix together before the epoxy was intended to be used. So for those reasons, it looked at the entirety as the product and found that the calculation didn't justify the Made in the USA claim that was being made. NARB recently affirmed, agreed with NAD. The advertiser has chosen not to comply with the recommendation, and so the matter has been referred to FTC. And we'll see what FTC does with it. We did want to note one thing to look out for is the policy guidance from FTC on Made in the USA claims date back to 1997. This year, FTC held a workshop and had a comment period looking at whether or not it should make revisions to that guidance, whether there should be rulemaking in the area. And so stay tuned to see whether or not there'll be some material changes with regard to FTC guidance on Made in USA claims.
So in the consumer space, there have been many decisions scrutinizing geographic origin claims on products. Again, let's look at two decisions from this year that came out differently on a motion to dismiss. So the first case, decided in June, challenged the entire Cascadian Farm line of products, which I think involved 81 products. And defendant argued that the Cascadian Farm brand name could not deceive consumers into believing that every ingredient in every product came from a Cascadian farm, because a brand can reference its historical origin without representing that the product's actually made there. And the court held that here consumers could plausibly be misled. And this is particularly the case because of the Skagit Valley, Washington emblem that appears on the package there that you can see on the slide. The court noted that the phrases on the emblem, which says, "Visit our home farm, Skagit Valley, Washington," since 1972, all of these phrases indicate a specific place that the products are purchased and that a plaintiff can go visit, and does not merely reference the historical roots of the brand. By contrast, in September, a court dismissed a complaint alleging that Hawaiian brand products were deceptively labeled to convey that the products were made in Hawaii when they weren't. And the court held that the word Hawaiian, combined with a single Hawaii-related image that you could see on the front there, simply could not deceive a reasonable consumer. Here, the court was persuaded by the absence of any geographic indicia related to Hawaii, such as a map or an emblem, that would indicate a place that the product is produced and a consumer can go visit. And the court held here, the packaging is only referencing Hawaii and its culture, and alone is not enough to deceive a reasonable consumer. So here, the distinguishing factor clearly is the emblem that appeared on the Cascadian Farm line of products. So next, signal ingredient claims. In the consumer space, it's a very significant trend. We can devote an entire hour to this trend. There have been many decisions, many filings, alleging that a product does not contain the signal ingredient, does not contain enough of the signal ingredient that a consumer, from reading the packaging, expects is in the product, or does not contain the particular form of the ingredient that a consumer believes that she is purchasing. But today, we'll focus on the impact of an ingredient list and whether it can cure a misunderstanding at the pleading stage. So first, this Post case decided in August. Plaintiff alleged that Honey Bunches of Oats cereal was deceptively labeled to convey the false message that the cereal was primarily sweetened with honey, when in fact the ingredient list showed that it was the 5th most prominent sweetener in the product. And the plaintiff pointed to the name of the cereal, Honey Bunches of Oats, pointed to the sun image, the image of the honey dripper dripping with honey, and also pointed to the image of the bee that you can see at the bottom of the package there. And the court dismissed the complaint and held that the packaging just makes no objective representation about the amount of honey in this product, which leaves the cereal's accurate list of ingredients as the only unambiguous representation of the amount of honey relative to other sweeteners. The court observed that this case is unlike those cases where the packaging misled consumers by inaccurately suggesting a particular amount of a key ingredient and distinguished a bunch of cases, nor is this a case where a product is entirely devoid of a food or ingredient that is part of its name, like this next case. In August, a divided First Circuit panel reversed district court's dismissal of a putative class action challenging hazelnut cream claim on coffee. Plaintiffs alleged that they believed, based on the labeling, that the product contained some hazelnut, when in fact the coffee contained no hazelnut at all. And the panel held, one might presume that a reasonable consumer who cared whether real hazelnut was in the product would check the list of ingredients. On the other hand, perhaps a reasonable consumer would find in the product name sufficient assurance so as to see no need to search the fine print on the back of the package. And the panel noted this was a very close question and actually observed that the panel themselves wouldn't be misled in this manner, but decided that it was best to let the jurors decide the issue on a full record. So moving from the First Circuit briefly to the Second, late last year, in December of last year, a panel held that white truffle-flavored extra virgin olive oil could not mislead consumers into believing that the product actually contained truffles. The panel was persuaded by the fact that the ingredient list contained no reference to truffle, and the front label described the product as only being truffle-flavored. Didn't say made with truffles or flavored by truffles. By contrast, just a week later, the Second Circuit held that the terms whole grain and made with whole grain on Cheez-Its could plausibly mislead consumers to believe that the product was made entirely or predominantly with whole grain, notwithstanding the disclosure on the front of the package that it was made with 5 grams or 9 grams of whole grain per serving. And the panel held that even with these disclosures on the front of the package, these claims in context still imply that the grain content is entirely or at least predominantly whole grain when that's not the case. And the court held that here, a reasonable consumer should not be expected to consult an ingredient list to correct a contradictory statement made on the front of the label. So the takeaway here, all of these cases are consistent with the principle that an ingredient list cannot be used to contradict a claim that's clearly made on the front of a label.
And turning briefly to NAD and ingredient claims, there was a lot of activity looking at the distinction between an ingredient claim and a product performance claim. It is a black letter principle at NAD, of course, that where the substantiation in the record consists solely of evidence regarding the efficacy of the ingredient in the product, but not for the product itself, the advertising must not suggest or imply that it's the product that's providing the claim benefit. And this Wink Naturals case, I think, well illustrates that principle. This case involves the claim our natural formula for this chest rub product contains safely diluted amounts of eucalyptus oils to open airways and lavender to calm and to soothe. There were other claims that were made in conjunction with this one, including that the chest rub can be used for decongesting and instructing consumers to apply to the chest and the neck area before bedtime to relax, rest, and breathe easily. Well, NAD found that, in fact, there was evidence submitted by the advertiser and a reasonable basis to claim that eucalyptus oil itself is a natural decongestant. But because of the construct of the claims and the context of the claims really were fashioned as an overall product claim, and so notwithstanding the ingredient evidence, it was insufficient to support the advertising. Among other things, the advertiser didn't provide evidence as to the quantity of each ingredient in the formula, any evidence as to how the ingredients interact with one another in the formula, nor any evidence demonstrating that there was sufficient eucalyptus in the chest rub product itself to act as an effective decongestant. And so NAD recommended the claims be discontinued. Another area we've seen this year, another trend, are challenges to implied or alleged implied health claims. And we'll stay on NAD to start. Another Reckitt case. This one involved the product at issue, a personalized fragrance box that contained a diffuser and was shipped directly to the consumer in her home. The exact amount of the natural essential oils that went into each fragrance was measured to maximize the fragrance experience for the consumer. And the claim at issue was scents crafted for your home wellness with 100% natural essential oils. Now, that claim was presented adjacent to an invitation to the consumer to discover the advertiser's aromatherapy collection. And that turned out to be a critical piece to NAD's analysis, the proximity of this claim to the term aromatherapy. NAD agreed with the challenger that the combination of those things communicated an implied health claim that was unsupported. NAD agreed that there is currently very little hard evidence or medical science to support the health benefits of aromatherapy, but it did not find the absence of such conclusive evidence to be dispositive. NAD noted that many consumers, while many consumers may believe aromatherapy is more of an art than a science, nevertheless, there are still many consumers that do in fact believe aromatherapy provides real therapeutic benefits. NAD continued to reason that there were a number of products in the market that touted aromatherapy as an objective, measurable benefit. And further, even consumers who don't believe in aromatherapy per se, nevertheless understand that it is used or intended to be used as a holistic healing treatment method. And for those reasons, NAD concluded a consumer could reasonably understand the claim, "Scents crafted for your home with 100% natural essential oils," to be communicating an objective health, home wellness benefit claim. And that was an unsupported message, and therefore the NAD recommended discontinuation.
So implied health claims, this is a new trend that we're highlighting this year, and it's a significant one in the consumer class action space. There have been several consumer class actions filed, several decisions regarding these type of claims. And the allegation is typically that the statements on the label of a product convey the message that the product is healthy, when in fact the product contains ingredients in certain amounts that can lead to health conditions. And typically the ingredient that's challenged is saturated fat or some other type of fat and added sugar. And we've got an example of each up on the slide. So the first case in September, a court held that consumers can plausibly understand cholesterol-free on coconut milk to convey certain health benefits that are not, that just don't exist if a product contains saturated fats above a certain level. Here, 3 grams of fat per serving. And in the Cliff Bar case, plaintiff alleged that claims such as nourishing kids in motion, nutrition for sustained energy, conveyed a health message that was deceptive because 37% of the calories in these products came from added sugar. And here, importantly, the court was persuaded by the fact that plaintiff alleged in, quote, painstaking and voluminous detail how this precise percentage of added sugars in Cliff's products can contribute to excessive sugar consumption, which in turn has been linked to many diseases and detrimental health conditions. So we'll keep an eye on these cases to see how they fare at the class certification stage, because at least one court this year denied a motion for class certification on an implied health claim. I believe it involved coconut oil. On predominance grounds. So again, we'll keep an eye on these.
Watch this space.
Yes.
So Lanham Act, touching briefly on implied health claims, the continuing yogurt wars. There was another fairly high-profile Lanham Act action commenced by Dannon against Chobani, involving the respective companies' drinkable yogurts that are marketed to children. The allegation was that Chobani had misleadingly advertised its yogurt product as containing 33% less sugar than Dannon's product. And on a motion for a preliminary injunction, the court actually agreed that Dannon had established a likelihood of success on the merits of proving the claim to be false and misleading. The claim was predicated on an overall sugar content analysis per ounce rather than per serving, and it was based on an average of all flavors rather than the specific flavor in question. So the court was persuaded in part by Dannon's survey evidence that could in fact be misleading, and that consumers would read the claim in a manner where they would get a false and misleading message. But that didn't end the analysis, and this is really a critical point, that in the preliminary injunctive analysis, it's not just your likelihood to succeed on the merits, but you also need to establish irreparable harm. And in this instance, the court found that Dannon had not met its burden in that regard. The court noted that Dannon's market share actually improved in the very month when the Chobani product was launched. In fact, it had its second highest month of market share ever that month. Secondly, with regard to Dannon's alleged reputational harm, the court pointed out that Dannon's product contained very high amounts of sugar. And so the court noted that even if the comparative claim were false and misleading, which the court found it was, if Dannon's reputation is going to be injured because of sugar content, the court noted that it is as or more likely to be injured by the absolute sugar content of its own product, which was indisputably greater than Chobani's. rather than the degree or the relative degree of the two products. And then further undermining the claim of irreparable harm, the court pointed to the fact that there had been a mistake on some Dannon packaging, and that packaging had actually overstated the sugar content of the Dannon product. So for all those reasons, injury undermined the ability of the plaintiff to secure a preliminary injunction in that case. So we're going to move on to questions of standing, preemption, and preclusion that we saw cutting across the advertising litigation space. But I want to stay for a moment on that concept of injury, because not only is it important in the preliminary injunctive context in terms of irreparable harm, it is critical to the question of standing under the Lanham Act. In fact, the Supreme Court a few years ago noted that injury proximately caused by the alleged false advertising is really the essence of the standing test under the Lanham Act. So this case in the Southern District of New York, which actually is a Kramer-Levin case, we represented our client TrueCar in this matter. It involved a claim by 108 plaintiff auto dealers around the country that sell various makes and models of automobiles that they were allegedly injured by TrueCar's advertising. TrueCar has an online automobile sales platform. Plaintiffs allege that the no negotiation, no haggle campaign that TrueCar ran was allegedly false and had caused them harm. And in the course of discovery, plaintiffs pointed to an expert that they would proffer as their sole evidence of injury in the case. No individual dealer who testified could point to any concrete injury. They all relied on their expert. And what that expert did was put in a report which claimed that there were 48,000 individual auto sales that were lost by individual plaintiff dealers to TrueCar dealers. The expert then took that 48,000 figure, multiplied it by the average profits per dealer in the United States, and came up with a figure of $77 million, and claimed those were plaintiffs' lost sales. That was the injury. We moved on Daubert grounds to exclude that expert because there was no attempt or no reasonable attempt by the expert to tie the injury, those alleged lost sales, to the advertising itself. They could have lost those sales for myriad reasons that had nothing to do with the advertising. And the court agreed and struck the expert's report and opinion, and that left plaintiffs in a real bind. So we moved for summary judgment, and this is where the role of injury is so important, because injury is an element of the claim. It's an element of standing, and it's an element of the claim itself for a false advertising claim. And we argued to the court without the expert, by plaintiff's own admission, it had no other evidence of injury, and so the case should be thrown out, and in fact it was. Citing the Supreme Court's Lexmark standing case that I noted, the court concluded that a plaintiff who does not come forward with evidence of injury proximately caused by the advertising does not have a statutory interest in deterring willful violations of the Lanham Act, and throughout the case. So really important, as I said, to not only be thinking about the merits of a case in the Lanham Act, but also to be thinking about harm. So turning to preclusion, when you have two federal laws that are in conflict with each other, and the same year the Supreme Court decided the Lexmark case, it decided the Palm Wonderful case, where it determined that you could have a coextensive Food, Drug, and Cosmetic Act issue with a Lanham Act claim, and one did not preclude the other in all instances. And so courts now grapple with the question on the particular facts at hand, whether there still can be preclusion in the wake of Palm Wonderful. And these two cases really illustrate how the specific facts matter in the preclusion analysis. The Ameren case out of the Federal Circuit, that was a situation where there was an allegation that certain companies were falsely advertising their imported, synthetically produced dietary products as, quote, dietary supplements. Because the products didn't meet the definition of dietary supplements in the Food, Drug, and Cosmetics Act, the plaintiff argued that it was false advertising, they were actually unapproved new drugs. The Federal Circuit affirmed a preclusion finding in that scenario because it explained the complaint admittedly relied on an FDA violation to support a key element of the Lanham Act false advertising claim. So that's a classic situation where proving the claim required proving a Food, Drug, and Cosmetic Act violation. That's classic preclusion. In contrast, in the high-tech case out of the 11th Circuit, there the allegation was a protein powders labeling, which described the product as ultra-premium 6-protein blend that contains 25 grams of protein per serving. The allegation was that deceived consumers into believing that one serving contains 25 grams, all derived from the 6-protein blend, when in fact only 17 grams were so derived because the defendant had allegedly spiked the product with non-protein content. The 11th Circuit found no preclusion because there the claim would require the court to determine only whether the protein content representations on the label were misleading to consumers in the context of the label's failure to specify the source of nitrogen non-protein content in the product. It would not require the court to interpret or to apply the Food, Drug, and Cosmetic Act in order to make that determination. And so the claim could coexist with the Food, Drug, and Cosmetic Act. So no preclusion.
Great. So staying with the theme of unapproved drugs, as Norm outlined, but moving from preclusion, which as Norm described, determines whether two federal statutes conflict with each other, to preemption, which analyzes whether a federal law acts as a bar to a state law claim. So as Norm mentioned, because there's no private right of action to enforce the FDCA, courts have held that state law claims, putative class actions alleging violations of state law that seek to enforce the FDCA are impliedly preempted by the FDCA. And the rule that courts employ in those cases is that to escape preemption, a plaintiff can sue for conduct that violates the FDCA, but can't be suing because the conduct violates the FDCA. And in this L'Oreal case, plaintiff alleged that defendant marketed its Revitalift line of products with anti-aging claims that were skin structure altering claims and therefore unapproved, therefore drugs which required pre-market approval, which L'Oreal did not get in this case. And the court held that plaintiff's claims were preempted for 3 reasons. 1, they exist solely because of the FDCA. 2, the claims essentially seek to enforce the FDCA. And 3, these claims conflict with the FDCA's discretionary enforcement process. Now, plaintiff appealed this decision, so we'll keep an eye on this case. And there have actually been a number of courts this year which have grappled with this issue, right? Whether anti-aging claims are essentially on products, make those products unapproved drugs. And courts have come out different ways on dismissal motions. In another case involving L'Oreal, the court actually stayed the action pending FDA review, and so didn't reach this preemption argument. In another case involving Nivea lotion, the court allowed the claims to proceed, but I don't believe a preemption argument was made. So we'll keep an eye on this trend.
And then touching on questions of preemption at NAD, there were a few cases that looked at NAD's Rule 2.2b6 this year. And what that rule says is that any complaints to NAD regarding specific language in an advertisement or on packaging or labeling, when that language is mandated or expressly approved by federal law or regulation, that should not be within NAD's mandate. Now, that rule has traditionally been read strictly by NAD and NARB, and there's 2 examples in 2019 of NAD doing just that. So in the Purdue case, there was a challenge to imagery of chickens in an open field that was contained on the label of the chickens, and the allegation was that implied that it was free-range or pasture-raised chicken. The advertiser argued that Rule 2.2b6 should preclude NAD review. NAD rejected that argument. By the way, the reason that allegation was made is under the Poultry Products Inspection Act, FDA is required to review all poultry labels before they can be offered for sale in interstate commerce. And so the advertiser said, NAD under Rule 2.2b6, hands off. NAD disagreed. NAD pointed out that the implied claim at issue really derived from non-mandatory label imagery, and there was no evidence in the record that the artwork was specifically reviewed by FDA or that any of the implied claims were evaluated for consumer perception by FDA to determine if they were false or misleading to consumers. NAD also noted that Rule 2.2b6 is expressly limited to language. It doesn't say anything about images that are required by federal law. And so NAD found jurisdiction and recommended changes to the labeling. The Oatley case was mentioned this morning, so I'll just touch on it briefly. There, NAD drew a distinction between the approved nutrition facts panel. If you've got a facts panel that's approved by FDA, that is not advertising. NAD will not exercise jurisdiction over the facts panel itself. However, NAD in this case drew a distinction between the panel itself and situations where the advertiser restates or uses the panel in its promotion. And here, although the label said 0 added sugar, the advertiser then, separate and apart from the label, touted the 0 added sugar. And because of uncertainty around the meaning of added sugar in the context of this product, which involves, in the making of the oat milk, there's a process of hydrolysis where you're not adding sugar, but you're nevertheless creating sugar as part of the process. So because of that uncertainty, NAD recommended the advertiser not repost or restate the 0 added sugar claim off of the nutrition facts panel. So let's move on to another area, free of claims. And at NAD, we had a dietary supplement case alleged to be 100% free of impurities or contaminants. The evidence that was proffered to NAD in this case showed that there were trace levels, which were allowed under a monograph. NAD said, well, that may well be the case, but a 100% free impurity claim on a nutrition product is a particularly powerful product to consumers. And so a consumer reasonably may care if there's trace levels. And trace doesn't mean 100% free, and so recommended that the claim be discontinued. NAD actually rejected the green guides in this case as being relevant because those, although the green guides allow trace elements, notwithstanding a trace element, you can still make a free of claim in the environmental context. In the nutrition context, that was not binding nor persuasive to NAD. So briefly, so we're running low on time. This was a high-profile case under the Lanham Act involving an allegation by Miller Coors and a motion for a preliminary injunction to enjoin Anheuser-Busch from making misleading statements relating to the use of corn syrup in Miller Lite and Coors Light. Now, corn syrup is used in the process of making those beers, but during the fermentation process, it's burned off, and it is not, corn syrup is not in the beer itself at the final stage. And so the court drew a distinction between two types of claims that were at issue. The claims that Bud Light had 100% less corn syrup than Miller Lite, and the claim that there was no corn syrup or other claims implying corn syrup was an ingredient in Miller Lite, those claims the court found the plaintiff was likely to succeed in proving were misleading, because as I noted, there is no corn syrup in the final product. However, there were other claims that Miller Lite and Coors Light are made with or brewed with corn syrup. The court found there, those claims, there was not going to be a likelihood of success in proving them to be misleading. The court relied on Seventh Circuit jurisprudence that doesn't allow you to take a survey to attack the ordinary meaning of a word, which is a very controversial decision. There's only the Seventh Circuit and the Third Circuits that hold to that doctrine. And so the court said you need something else other than the words themselves to convince the court that there's likely to be an implied claim that the product contained corn syrup. And the only thing that the plaintiff could point to was the pervasiveness and the scale of the advertising campaign. This was a big commercial during the 2019 Super Bowl, made a lot of impact in the market, but the court said that that in and of itself is an insufficient ground to find that a neutral, truthful statement is misleading within the meaning of the Lanham Act, and rejected a finding of misleading with respect to those claims.
Okay, so free of claims have been a significant trend in the consumer class action space for several years now, and I view them essentially as a corollary to the natural claims trend, which remains a trend, but we don't delve into today because we did a deep dive on this yesterday in a breakout that I hope you were able to attend. But free of claims are challenged where the product contains the listed ingredient, contains a similar ingredient that's associated with the same harms, or contains an ingredient that in turn contains the listed ingredient or breaks down into the listed ingredient. And we thought this Nestle case was an interesting twist on the free of trend. So here, plaintiff alleged that Nestle's no GMO ingredients claim and seal was very similar to the non-GMO project's claim and seal, and deceived consumers into believing that Nestle products actually met the non-GMO project standards, which were much more stringent than Nestle's standards. And the court agreed that that was a plausible communication from that seal, and allowed the claims to proceed. So this is something else to be mindful of when you or your clients are developing claims and imagery based on your own standards. So a significant subtrend in the free of space are cases challenging no preservatives and no artificials claims, where the product contains an ingredient that's allegedly artificial and allegedly acts as a preservative or a flavor. And we touched on this briefly yesterday, and I know Ron touched on this briefly this morning, but we highlight it here because it really is very significant in this space this year. So far, in 2019, there have been at least 3 decisions on no preservatives claims where the product contains citric acid, and at least 6 decisions on no artificial flavors claims where the product contained malic acid. And these cases largely survive dismissal. Courts find that whether or not the defendant is using the artificial version of the ingredient, and whether or not that ingredient actually acts as a preservative or acts as a flavor rather than some other purpose, are questions of fact that can't be resolved on a dismissal motion. However, last month, court dismissed an action alleging that defendant falsely labeled Capri Sun no artificial preservatives when the products contain industrially produced citric acid. And here, plaintiff alleged that while citric acid can be produced naturally, it's more economically viable to produce it synthetically, and for that reason, alleged that the citric acid included in Capri Sun was synthetic. And the court said, no, that's just too great an inferential leap. Plaintiff doesn't actually allege that defendant used the industrial process to produce its citric acid, and for that reason, dismissed the complaint. So it's encouraging to see courts, holding plaintiff to their pleading burden.
Always encouraging. Finally and last, next is SCOTUS Watch. We wanted to put on your radar screens a case that it will be decided by the Supreme Court that will have a significant impact in the advertising space. Under the Lanham Act, among the remedies that are available to a plaintiff is recovery in the form of disgorgement of the alleged false advertiser's products as a substitute for recovering your own lost sales. There has been a long split between the circuits as to whether or not, in order to avail itself of that remedy, a plaintiff, as a predicate showing, must prove that the defendant engaged in willful behavior, willful false advertising. In 1999, the Lanham Act was amended. The remedy provision of the act said, with regard to allegations of trademark dilution, willfulness is required for disgorgement. With regard to everything else, trademark infringement and false advertising, the word willful was not expressly added by Congress. And so since that amendment, and even before, frankly, there are some courts that look to that distinction in the act to say willfulness is not a prerequisite. It might be a factor to be considered, but it doesn't have a gatekeeping function. And then the other half of the circuits go the other way and say, no, you must, as an equitable principle, going back to common law, you need to have a showing of willfulness as a predicate to a disgorgement remedy. And commentators have been talking about this for a long time. Finally, SCOTUS has accepted cert on the Romack Fasteners case and is going to settle this issue once and for all. So we hope next year at BAA to be talking about the resolution of this as a trend for 2020.
Yep.
So that brings us to the end. We wanted to thank you for your attention. It's always a pleasure to be here. And we did want to note that what we do each week is we have something called the Advertising Litigation Report that compiles all of these cases that we've been talking about, and every Tuesday morning shoots out an email with a summary of those cases. And if you're interested in getting that, We have a Kramer 11 table with a fishbowl. You can drop a business card in there and we'll add you to that list. You also have a chance to win an AirPod, which is kind of cool. And we're particularly proud that we're launching at BAA this year an app, the Kramer 11 Ad Lit Report, and that will have all of the content of those reports going back, including archive material, fully searchable, and other bells and whistles. And you can download that at the Apple Store, Google Play, or at that link. Thank you for your attention. Enjoy your lunch. We'll see you at the conference.